So what are your reflections on the 4-day interview process?
Sorry, it cut out again. I think you're asking for my comment on the process. I mean, obviously, Judge Meyer is one of the 4 distinguished jurists that was interviewed in this process. Unfortunately, the process itself was so corrupted and degraded. So while I certainly understand that many will want to applaud the fact that we have the possibility of the first female Chief Justice being appointed, I think the fact that it results from so corrupted and degraded a process, as we saw play out this last week, is hugely unfortunate.
So let's speak to that, corrupted and degraded. Explain to us what made it so, please.
Well, I think as we saw on Friday night, for instance, those interviews which were intended to probe the fitness of the candidates for the top job in our judiciary descended into a screaming match with Commissioner Malema screaming at Justice Minister Ronald Lamola, them essentially using these interviews as a pretext to wage a political fight. So those questions obviously not going to the fitness of the particular candidates. We saw Judge President Dunstan Malambo, him not having been given any notice, in contrast to what is the practice of the JSC, that there would be a line of questioning put to him that consumed over 2 hours of his interviews that related to entirely unsubstantiated rumor of sexual harassment. No facts, no credible allegations were put to him. It was enormously difficult for him to engage and to refute those definitively with so little actual information given to him. We saw some of the questions put to Justice Meyer, who, sort of results as the preferred candidate, really softball, almost patronizing questions given to her as if she was not equal to more. And of course, those interviews then sort of interrupted with some really kind of sexist, unfortunate sort of interventions. So, one of the commissioners, Dali Mpofu, feeling that he can engage in sexual innuendo with our first candidate be seriously considered for the position of Chief Justice, Commissioner Malema at one point instructing a journalist through the chair to take her medication, all of that going to suggest that whilst the commission is suggesting that they have waged this great feminist fight, in fact, many of the commissioners don't know the first thing about what it means to be feminist, to be a non-sexist, and to not act in a patronizing manner in respect of both female candidates and any woman.
So let's just speak to this fitness to hold office and gauging any of the candidates' fitness to do so. What sort of questions are out of bounds here?
Well, I think questions where you're actually not asking for the candidate to provide their information and sort of expression of their understanding of principles relevant to their job, the way in which they've engaged in their judicial duties before. So, for instance, when 2 commissioners are shouting at each other about some incident peripheral to what they're asking the candidate about, those are not questions that go to fitness. Where you're putting to a commissioner a line of questioning which you have no facts, no credible allegations that they can actually substantively engage in. Those don't go to fitness and propriety of the candidate. Continuously asking, the candidates whether South Africa is ready for a female Chief Justice. I mean, it's not their business to be able to reflect what society is as at large feels about such a development, nor does it say anything meaningful about their fitness and suitability to be the Chief Justice. So I think again and again we saw questions put to the commissioners that actually didn't engage with their fitness.
So let's cut to the chase. Let's go to the question about sexual harassment that was put to Dunstan Mlambo, Judge Mlambo. So to that particular point, and I think he was asked whether he was aware of such allegations, and his response was that he was in fact aware of said allegations, and allegations as it is, as you said, nothing had been proven and nothing more seemed to have come out of that. But is that not important for us as a society to know about someone who could potentially be the chief jurist in this country? Should we not know all there is to know about them?
Absolutely. If there are credible allegations, it was no more than rumor that he had actually heard rumor. As I said, the practice of the JSC is to put to commissioners the lines of questioning that they intend engaging them on so that they can prepare for it. So if the commission felt that these were issues that they wanted to interrogate the respective, they needed then to actually notify the candidate so that he could prepare and not be blindsided. But one other thing that I would say, Judge President Malambo said when confronted with these rumors, he said the judiciary and the legal profession is notorious for its rumor mongering. And sorry to say, but that is in fact true. And so for any candidate who has spent a long time in the judiciary and the legal profession to be able to say that there have been no rumors regarding them is completely would be completely unrealistic. And so the fact there had been some scurrilous rumor about him certainly doesn't mean that it is of consequence for public notice. Without a substantive allegation, it is not of sufficient consequence to be brought to public notice, and certainly not to be used as it was, I think, in order to smear the candidate.
So when you say it was used to smear the candidate, please explain that for me, because what's the difference between using such rumor to smear a candidate and highlighting something that could be potentially very important given the scourge of gender-based violence and rape in this country that we live in?
So if there is a line of questioning that consumes over 2 hours of the candidate's interview process, then there has to be something more, right, to warrant 2 hours of questions. And so, yes, if those rumors, if you could in some ways identify, I mean, not necessarily publicly disclose, but identify in some manner who those persons were who were the victims of these ostensible sexual harassment claims. Where do they emanate from? In what context did that happen? Where was it in the court process? Was it, when he was practicing as a lawyer? If there was some form of identification, some real credible, engagement that was allowed the judge president, so they could definitively put that. But given that it was just rumor, and he said it was just rumor, that he had heard this said, that he had heard this, that there had been this rumor, that he could take it no further, he did not know from where this rumor emanated, to press for over 2 hours takes that interview nowhere, and as I say, ultimately amounts to a smear.
So looking at the process, and this is, of course, the prerogative of the president ultimately to appoint the Chief Justice of his choice. What do you make of that and the process as it did unfold, as opposed to perhaps the president just exercising the powers conferred upon him to appoint a Chief Justice? So,
as you rightly say, this is an unprecedented. The Constitution does not require that we engage in this process in order for the Chief Justice to be appointed. The Constitution gives the power to Chief Justice, to the President, to make such appointment after having consulted with the JSC and leaders of political parties, National Assembly. What has happened in the past is that the President has simply notified the JSC of the person he intends appointing to the Chief Justice role, and they then interview the candidate. I think President Ramaphosa sought to introduce this process in order to enhance the exercise of his powers. I would say that given what those interviews descended into last week, far from enhancing the exercise of his powers, they have detracted from the exercise of his powers, and that he would be within his rights to disregard the proceedings of last week, to simply act as if they hadn't happened, and make it known who he intends to appoint, and then for him to consult in the customary way with the JSC as to that candidate.
So what would then be the point of having gone through this very lengthy public process if, in fact, the president then just reverts to the original position and powers conferred in the Constitution? What would have been the point, if not a wasteful and fruitless exercise?
Unfortunately, that may be so, and sorry you were breaking up, but unfortunately that might be so, that it was a wasteful, fruitless exercise, but that might be the best that we can do with the proceedings of this last week, because I think they were exactly that, a wasteful and fruitless exercise. The president can disregard it, and in fact, arguably should disregard it, because that process was irrational. It was an exercise of public power that ultimately was irrational, that so many of the questions did not go to serving the role and function of the JSC, which in that context was to probe the fitness of the candidates for the Chief Justice. And as such, as an irrational exercise of public power, that it then must be disregarded, because to take it into account would be to taint the president's exercise of his powers to appoint.
So how do we arrive at the point of declaring it an irrational exercise, Nicole? Given the myriad of questions that were posed over 4 days, and if you have, out of those, maybe 10, 20, 100 questions out of thousands of questions that were asked, how do we determine why or what constitutes this to be an irrational exercise?
Well, it's difficult to say, what proportion of those questions were not ones which went to probing the fitness of the candidate's fitness or suitability for the office. But certainly there was a large proportion of such questions. And so the exercise as a whole, if tainted by irrationality, is then, subject to vulnerability and potential challenge. But
let's probe that a little bit.
But as I say, it's looked at in round.
So if we probe that further, so if you say the process is tainted by irrationality, are we able to pinpoint exactly those moments of irrationality, and what percentage, if we were to weigh this up, would that constitute in the broader process that went over 4 days of these interviews and a public process that started before?
It would be difficult. I mean, at this point, it would. That is an exercise that can be done. It should be said that, if we're talking about a challenge before courts, it's not about a percentage, right? In fact, courts, when they're viewing for irrationality, they will say, even if there is, one element of irrationality that potentially vitiates or taints the entire process. But, for instance, as I've indicated, I mean, if we just take Judge President Dunstan Nalambo, there were, and just one line of questioning, which consumed 2 hours, and ultimately was an irrational, and not only irrational, an unfair exercise of the JSC's powers. That was a considerable, not insignificant indication, demonstration of irrationality, and as I said, not only irrationality but unfairness.
Given the composition of the JSC, why wasn't it raised by any of the commissioners, amongst whom sits the whole minister as well? Why didn't anybody raise that prior to the 2-hour prolonged discussion upon it and make the point that this would constitute this whole exercise irrational?
I think that obviously an issue was raised because, coming back from the break, the chair then ruled that those questions would be expunged. But of course, the damage had been done, and that 2 hours of the interview had been consumed by that line of questioning had not been was not necessarily undone simply by the ruling that it would be expunged from the record and would not be taken into account in the deliberations.
If we look at the question
but the other issue.
The question to the acting Chief Justice about his meetings with the former President Jacob Zuma. Let's talk to that in terms of rationality here. What did you make of those questions?
So sorry, breaking up. I just heard a question regarding former President Zuma.
Yes, the questions that were put to the acting Chief Justice.
About his meetings with the former President Zuma. Well, I thought that was another indication of sort of really, I mean, perhaps not irrationality, but really deep irony. So Commissioner Malema asks acting Chief Justice Zondo, about his meetings with the former president. It turns out that one of the reasons that the acting Chief Justice Zondo had, met with the former President Zuma was in relation to utterances that Commissioner Malema had made when he was then head of the ANC's Youth League, and that he had said that he would kill for President Zuma. And it seems that acting Chief Justice, he wasn't then acting Chief Justice, but Judge Zondo was very concerned about such utterances in a constitutional democracy and the extent to which they erode our constitution. And the irony, of course, is that you have a commissioner who is suggesting that there's something improper in a judge saying to our former president, you need to rein this type of discourse, this type of language and threat in because it is so damaging to our constitutional democracy. And yet the person who is making such imputation, who's making such allegation, is in fact the person who made those utterances and who sits on the commission. So this person who said that he would kill in defense of President Zuma gets to sit on a selection body that chooses not only our Chief Justice,